In early 2026, the Supreme Court of India faced a massive, coordinated legal offensive. Over 65 review petitions landed on the docket, all targeting a single, highly disruptive judgment from the previous year. The 2025 ruling delivered a harsh ultimatum to veteran in-service educators: pass the teacher eligibility test or lose your job. This threatened to invalidate thousands of established careers, terminating educators who had been teaching for decades, right in the middle of their service. The teachers mounted their legal defense on a core pillar of service jurisprudence: the rule against retrospective application. Their argument relied on a straightforward assumption: they were legally hired under the recruitment rules of their time. Imposing a brand new mandatory qualification years later severely prejudiced their established conditions of service. The court, however, declined to dismiss these claims using broad policy arguments about educational standards. Instead, the justices dismantled the retroactivity defense entirely through strict semantic interpretation of the statute itself. To understand how they did this, we have to deconstruct the specific language within the Right to Education Act that defeated the teachers' claims. The resulting judgment exposes the sharp collision between adult employment security and a constitutional mandate to guarantee quality education for children. The teachers brought their case using a specific procedural vehicle, the review petition, governed by Order 47, Rule 1 of the Civil Procedure Code. This jurisdiction has severe limitations. As the court noted, citing precedent, a review petition cannot be an appeal in disguise. You cannot demand a second look just because you lost. To succeed, the petitioners had to meet an incredibly high threshold. They needed to prove an error apparent on the face of the record, a mistake so obvious it strikes you by merely looking at the document. The teacher's strategy leaned heavily on the perceived injustice and mid-career hardship caused by the new requirements. But a perceived change in service conditions, or presenting a different legal opinion, does not legally qualify as an apparent error. To win, the teachers had to prove the court objectively misread the text of the Right to Education Act. This forced the bench to perform a surgical re-examination of the statute. The entire debate over retrospective application centers on this text, Section 23 of the Act. Look at subsection 1. The legislature deliberately starts the provision with the words "any person." In legal drafting, this phrase inherently dictates prospective eligibility. It establishes the baseline qualifications for unhired future applicants. But drop down to the first proviso of subsection 2. The legislative phrasing shifts. The text now refers to a teacher. This distinction is highly intentional. A teacher explicitly denotes an individual who was already born in service when the act commenced. The proviso serves a very specific functional purpose. It grants a 5-year grace period for these existing employees to acquire the new minimum qualifications. The government later passed the 2017 Amendment Act to extend this exact compliance window, giving teachers in position as of March 2015 an additional 4 years. This semantic distinction is devastating to the petitioner's case. It proves that applying the TET requirement to veteran teachers was not a retrospective judicial invention. It was a legislative mandate baked into the law from day one. Because the parent statute contains this explicit text, it legally overrides general rules of service jurisprudence regarding changed conditions. The retrospectivity argument collapses entirely because the legislature made a deliberate choice to use the noun teacher instead of person. The petitioners then fell back on administrative exemptions, specifically citing a 2010 notification from the National Council for Teacher Education. The court dismissed this using a foundational maxim of administrative law: subordinate legislation, like an agency notification, can never override the clear intent of its parent statute. The teachers deployed one final textual defense. They pointed to the first proviso of Section 12A of the NCTE Act, which appears to protect pre-amendment teachers from being fired solely for lacking new qualifications. The fatal flaw was they read the statute selectively, stopping where the text supported them. They ignored the very next clause. The second proviso explicitly states that these minimum qualifications must still be acquired within the period specified under the RTE Act. This creates a closed legal loop. The NCTE Act routes the teacher's requirements directly back to the strict statutory timeline of the Right to Education Act. Cherry-picking subordinate clauses fails when the entire architecture of the legislation is built to serve a single unified objective. The court's textual logic was legally airtight, but enforcing that pristine logic immediately would yield a catastrophic result on the ground, instantly disqualifying massive swaths of the educational workforce. At this point, the court had to recenter the actual objective of the law. The Right to Education Act does not exist to protect teachers. It exists to serve children. This presented a severe paradox. Enforcing the children's Article 21A right to qualified instructors risked collapsing the very school infrastructure those children relied on to learn. To solve this systemic trap, the Supreme Court invoked its ultimate constitutional release valve, Article 142. Article 142 grants the court the power to pass any decree necessary for doing complete justice, allowing them to prioritize pragmatism when a rigid application of the law would cause systemic failure. Exercising this power, the court granted extraordinary, limited relief. They overrode the statutory deadlines, extending the TET compliance window for in-service teachers from 2 years to 3. A new, hard deadline was set for August 31, 2028. To make this achievable, the court mandated that states conduct TET exams, preferably twice a year. Crucially, this extension was granted without conceding a single inch of legal ground. The court maintained absolute fidelity to the doctrine. The TET remains a mandatory constitutional necessity. The Anjuman Review presents a court that is completely unyielding in its textual logic, yet highly pragmatic in engineering timelines to prevent the collapse of the public systems it oversees.